All right, while we're waiting for that, I think we can go forward because there is a threshold issue, kind of legal issue that I want to address. So let's go on the record. People versus Clifford McNamara. This is Kalkaska file number 244932. If I can have counsel put your appearances on.
Your Honor, Ryan Ziegler on behalf of the people.
Your Honor, Thomas Seeger appearing with and on behalf of Mr. McNamara.
All right, the record should reflect we are connected with the Waxford County Jail where Mr. McNamara is lodged. However, he's not currently on the camera. Mr. Seeger, oh, there he is. Okay, great. So we have Mr. McNamara now present on the camera. Mr. McNamara, are you able to hear me? You can just wave your hand if you're able to hear me, okay? Yeah, okay, great. So he's indicating for the record that he's able to hear us. So we'll go forward. The first issue I want to address, we have Mr. Miller connected from the Manistee County Prosecutor's Office. He filed a motion pursuant to the subpoena that was issued for the hearing today. Mr. Seeger, did you receive that motion?
I did, Your Honor.
Okay. Mr. Miller, if you could put your appearance on for us, please.
Good afternoon, Your Honor. Jordan Miller from the Manistee County Prosecutor's Office.
Okay, I did have a chance to review your motion to quash the subpoena with regard to your testimony, Mr. Miller. Is there anything that you wanted to add here for the record other than what is in your written motion?
Your Honor, I just I appreciate that the court has allowed me an opportunity to be heard on this. To me, this is, Your Honor, this is just one of those situations that it sets a dangerous precedent, in my opinion, to compel a prosecutor to have what are essentially privileged communications that occur between a prosecutor and a victim, to then compel a prosecutor to testify about those conversations. To me, this is sort of an unheard of protocol. I'm not blaming Mr. Seeger. I understand the route that he is taking, and I understand why he's doing it. To me, however, Your Honor, I think this flies in the face of the Victim Rights Act. We as prosecutors are tasked in our capacity as prosecutors with being able to speak frankly and privately with crime victims so that we can do our jobs. And unfortunately, as we all know, especially in the case of domestic violence cases, victims recant for a myriad of different reasons. And it's not always because what happened in the initial allegations were untruthful, but rather because in the face of their loved one being prosecuted, they suffer financial strain, they feel guilt, they fear retaliation. There could be many different reasons why a victim chooses to recant their testimony. That does not mean that their original allegations were untrue. And so the very essence of us being able to do our job as prosecutors entails having those frank conversations with victims and making assessments as to how we proceed with our cases and how we administer justice. And to suggest that any one of those conversations could then become fodder for collateral litigation and compelling prosecutors to have to testify about those conversations is, in my opinion, a very dangerous precedent to set. And so I'm very strenuously in opposition to being compelled to testify here today. Having said that, I do recognize that I'm under subpoena. I recognize the authority in this matter. So ultimately, it is the court's decision, and I will comply with the court's decision. But I just wish the court to know that I very strenuously object. I have questions and concerns about whether or not this type of evidence would even be admissible in this type of proceeding, not only pursuant to our rules of evidence, Rule 608. You're asking me to opine on a specific instance of this victim's untruthfulness or character for untruthfulness, which frankly, I really can't give you any definitive answer as to whether she was telling the truth one time or the other. And I don't believe that my being able to testify as to that would actually fit within the parameters of the court rules, which I recognize is something separate and apart from, my threshold issue as to whether I can even be compelled. But I'm just trying to make the point, Your Honor, that, I think we go down a dangerous path here. I know I did list some case law in my motion. Trooper Hoffmeister and I have not discussed this case recently. I do recall having some conversations with him early on, And I have every reason to believe and suspect that some of the same things that the victim told me, she also told him. So my position on this matter is that any testimony that I could provide in this case would be duplicative, and therefore, under the case law that I've cited, would alleviate my need to be called as a witness. So with that, Judge, I would just simply assert my position in this matter that I don't think I should be compelled to testify, and I would ask the court to consider quashing the subpoena and allowing me to be freed from that.
All right, thank you. Mr. Ziegler, on behalf of the Kalkaska Prosecutor's Office, do you take any position one way or the other on Mr. Miller's motion?
I do, Your Honor. I agree with Mr. Miller's sentiments on the record today and with his motion to quash. And I even mentioned it in my response to Mr. Seeger's motion on pages 8 and 9 that I did not believe that, number one, the court had the authority to subpoena a prosecutor to give testimony about particular executive branch decisions that are fully within the discretion and scope of the executive. And there is case law to support that position. I cited People versus Gilmore for that effect. I would also note that while Mr. Miller relies on the Crime Victims' Rights Act, and I think that's a perfectly good basis for his motion, I would also point the court to the work product doctrine and the work product privilege, which is at MCR 2.302B3A. And essentially, the work product doctrine says that if materials are prepared in anticipation of litigation, that they're not subject to disclosure, they're not subject to discovery, they're not subject to subpoena, they're privileged. And the point of that is obviously that if a prosecutor is preparing for a case, and necessarily in preparing for a case, a prosecutor at some point needs to talk to the victim of a crime to ascertain what that victim's testimony is going to be. Those discussions are privileged. If there are notes that are taken from those discussions, those are privileged as well. I can't subpoena the defense and ask for notes from conversations they've had with a witness. They can't subpoena me and ask for notes that I have from discussions with a witness. And so what Mr. Seeger is asking is not just for notes, it's for this attorney's recollections that are going to be tainted and bear the indicia of his own evaluations of credibility, his own memories, the things that he was focusing on in those interviews. All of that should fall under the work product doctrine as well. Mr. Seeger is attempting to get at another attorney's evaluation of his own case and use that against the victim in that case and in this case. And I think that's improper for all the reasons Mr. Miller cited, as well as for the work product doctrine. So I would support the motion to quash, Your Honor.
Thank you. Mr. Seeger?
Your Honor, I subpoenaed him. It's up to the court to decide. The prosecuting attorney represents the people of the state of Michigan. I think that that's somewhat distinguishable from representing a particular client. And as much as I represent Mr. McNamara, he does not represent Lauren McNamara. He represents the people of the state of Michigan. Additionally, Your Honor, it's an unrelated case, and primarily the reason why he was subpoenaed is related to his own order of dismissal, which arguably would be a document that I could obtain, certified document. And it's not really controverted. I don't know exactly what Officer or Trooper Hoffmeister is going to say other than what I had spoken to him about. I assume it may be possible that the testimony of Prosecutor Miller is very similar to that of Trooper Hoffmeister. This is an evidentiary hearing, so to the extent that the court is going to make a ruling, maybe it can make a ruling following the testimony of either, and then you can go from there, Your Honor. But I mean, as far as I can tell, I don't think he's disqualified. I think it generally speaking, no one wants to be compelled to testify under any circumstance. And so to the extent that he doesn't wish to testify, well, just like the prosecuting attorney said, they have the ability to charge and dismiss cases as they wish. What that reasoning is somewhat spelled out in the order of dismissal. But what non-cooperation means, Your Honor, I'm not entirely sure what that means because I can only read the order as it's written. I assume that non-cooperation includes recanting, which I assume will be the testimony of Trooper Hoffmeister, which may be the testimony of Mr. Miller. I don't specifically know what that testimony will be, Your Honor. I was just merely going to go through the report to determine whether or not some of these items are admissible. And so I subpoenaed Trooper Hoffmeister, who was kind enough to accept subpoena by email, and Mr. Miller, who was likewise courteous and accepted on short notice subpoena by email. So I'm not attacking anyone, Your Honor. I'm just merely saying that I don't think that anyone's specifically disqualified or immune from testimony simply based on their position.
Okay, all right, thank you. I did have a chance to review the motion that was filed by Mr. Miller. And I was familiar with the circumstances because we did have a hearing on this last week. So this wasn't necessarily unexpected. I think this is certainly an unusual occurrence where a defense is trying to subpoena a prosecutor from a different jurisdiction regarding the circumstances of a different case. And in particular, I'm looking at why do we need this information, or why is the defense seeking to obtain information about dismissal in Manistee County and the circumstances surrounding that. And the motion is to admit evidence under 404B, 607, and 608 regarding the credibility of the complaining witness in this case. And so the court's looking at how is the testimony of Mr. Miller going to be relevant to those things? And if it is relevant, is it admissible, given the objections that the prosecutors outlined here? And I think really, in order to get at what the defense really wants here, the defense is going to necessarily have to inquire into the reasoning behind the dismissal of those charges. And that's going to lead to questions about discussions that were had with the complaining witness in that case. And the underlying basis for the dismissal, given her answers to those questions and discussions that they had. And I'm fairly confident in reviewing the law cited by Mr. Miller that is invading the province of the prosecutor's office here in terms of requiring him to testify as to why they did or did not proceed with charges in this case. And I agree with Mr. Miller. There's a variety, even assuming that the testimony would be that the complaining witness recanted. There could be a variety of motivations for that, other than that her original statements were not the truth. I mean, she could have been truthful regarding her reports to law enforcement, and then changed her mind about sticking to that story for various reasons. While that could still, I guess, go technically to her credibility, I think requiring the prosecutor's office again to testify as to those discussions, as to their reasoning for dismissing, and even going into the wording that they used in the order of dismissal, non-cooperation. I think that's necessarily going to lead to testimony questions about, again, the exercise of the prosecutorial tough time with that word today, prosecutorial discretion, which I think would be impermissible. And I agree with Mr. Miller, just generally a bad precedent to set. So for those reasons, the court will grant the motion to quash. And Mr. Miller, I'll just ask that you submit an order, either with a stipulation as to form from the other counselor under the 7-day rule, just so that we have an order reflecting the ruling of the court here today for the file in case there's appellate issues later.
I can do that, Your Honor. Yes, thank you.
Okay, and Mr. Miller, you're free to stay for the rest of the hearing and remain connected. You're free to disconnect. That's up to you.
Thank you very much, Your Honor.
Okay. Going forward then, Mr. Seeger, did you want to take some testimony from Trooper Hoffmeister today?
I do, Your Honor.
Okay. Trooper Hoffmeister, if you can unmute your microphone, please. You raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. And Trooper, if you can state your first and last name and spell both for the record.
Trooper Logan Hoffmeister, LOGAN HOFMEISTER.
Thank you. Mr. Seeger, proceed whenever you're ready.
Thank you,
First of
Your
all,
Honor.
I just want to, I think we addressed this on the record, but counsel, you both have no objection to taking this evidentiary portion of this hearing by video today.
No objection, Your Honor.
No, sir.
Okay, thank you. Go ahead and proceed, Mr. Seeger.
Thank you, Your Honor. Trooper Hoffmeister, you currently work for the Michigan State Police, is that correct?
Correct.
All right. And then on or about Tuesday, September 3rd, 2024, you were dispatched to a assault involving Lauren McNamara and James McNamara.
I was.
All right. And that was following a 911 call that was made by Ashley McNamara.
Correct.
And it was advised that Lauren had been physically assaulted by her husband, James McNamara.
Correct.
And that at some point in time, he had pointed a firearm at his daughter. Is that right?
At his daughter and also at Ashley McNamara.
Okay. At which point she had indicated that James had allegedly said that he was going to give her an abortion. Is that correct?
Correct.
All right. And this argument was precipitated by a mail that was on her Facebook account.
Yes.
All right. And Lauren stated that James had retrieved a shotgun from the kitchen cabinet.
From on top of the kitchen cabinet, if I remember correctly.
Okay. And then Lauren advised that James pointed the shotgun at their 2-year-old daughter and Lauren to say their goodbyes.
Yes.
Okay. Then at some point in time, you did in fact talk to James. Is that correct?
I did.
And James had said that Lauren is crazy. Is that correct?
I believe that was his statement. I believe his statement was that she is crazy and that he is worried about her mental health.
All right. And during the course of your investigation, you were unable to find a shotgun. Is that correct?
Correct.
Despite it being alleged that it was used during the course of that particular incident. Is that correct?
Correct. It was alleged that James had grabbed the shotgun and their child and had left the residence and was gone for some time. And at that point, the shotgun disappeared.
And so you responded following the dispatch phone call. I assume that you went out to the residence quite quickly. Is that correct?
Correct.
All right. So there was not like an inordinate amount of time wherein, you didn't appear on scene. Is that correct?
There was a short amount of time where we were searching the area for James. We didn't immediately go to the residence because Ashley was with a neighbor and was safe. And so our main priority was locating James and the child. So we did not go directly to it. There was like about a 15-minute time period where we were searching for James prior to him showing back up at the residence.
All right. So, but at no time did you find a firearm at the house or in a vehicle or anywhere else. Is that correct?
Correct.
All right. And subsequently, you filed a request for charges to be filed. Is that correct?
I did.
That included domestic violence. Is that correct?
Correct.
Assault with a dangerous weapon.
Correct.
Assault by strangulation.
Correct.
Okay. And subsequently, he was charged with assault with intent to do great bodily harm less than murder. Is that correct?
I believe so.
All right. Assault with a dangerous weapon.
Correct.
Interference with electronic communications device.
Correct.
And assault with a dangerous weapon.
Correct.
And ultimately, those matters were dismissed by the prosecuting attorney. Is that correct?
Correct.
And that's because the complaining witness had recanted her story. Is that correct?
Yes. I went there back to her residence a couple days later to provide her a subpoena. And at that point, she advised me that she wanted to recant her statements from the night of the assault.
All right. And so she essentially said that the statements that she had made previously were untrue. Is that correct?
She didn't say they were untrue. She just said that she was in the right state of mind and would like to recant. She never said that they were true or untrue or anything like that. She wanted to recant.
All right. So she subsequently recanted her earlier version, whether or not they were true. That's what she did. Is that right?
Correct.
At which point the prosecuting attorney, are you aware of whether or not the prosecuting attorney had an opportunity to speak with the complaining witness?
I know he had spoken with her. However, we did not communicate between each other about what was said between those two.
All right. Are you aware of whether or not she recanted her version of facts to the prosecuting attorney as well?
I believe she did, but I don't know exactly what was said between those two.
All right. So it's your belief that Miss McNamara recanted her version of events to the prosecuting attorney. Is that correct?
Correct.
And she also recanted her version of the facts to you specifically. Is that correct?
Correct.
All right. And ultimately, based on that, was that the non-cooperation that we're referring to in the order?
Yes.
All right. And also in the order of dismissal, it says there was no corroborating evidence to prove the charges. Is that also true?
The only evidence we had towards assault would have been the broken necklace, Ashley's broken purse, and then the scratch marks on her neck and the bruising on her neck, and
All right.
bruising around her mouth as well. Other than that, there was no other evidence.
Okay. But the matter was dismissed because they did not believe they were able to meet their burden of proof. Is that correct?
Correct.
All right. I don't have any further questions, Sean.
Thank you. Mr. Ziegler?
Trooper Hoffmeister, so there was some physical evidence when you arrived on scene that some kind of altercation had taken place,
Correct.
and that I think you mentioned a broken purse.
Yes, there was. Ashley's initial statement to me was that James had pulled her to the ground by the purse she was wearing, and in doing so, had ripped the strap off of the purse.
And you're referring to an Ashley. Are you referring to Lauren Ashley McNamara?
Correct. Sorry.
Okay. So the broken purse would have been consistent with her version of events.
Correct.
And then you said there were scratches and bruises on her neck. Were those consistent with her version of events as well?
Correct. She had said that her necklace was ripped off as well during a struggle, and there was a linear scratch starting from about the below her chin down towards her chest. That would have been, that would have indicated that the necklace was ripped off with some force. And then there's also bruising on the sides of the neck and bruising around the mouth.
And then you found that broken necklace as well, correct?
Correct.
And that also would be consistent with her version of events that it was ripped from her neck?
Correct.
Where did you interview Lauren McNamara at that first contact? Was that at her house or was that somewhere else?
I initially made contact with her at the neighbor's house where she had gone to be safe.
And when you say neighbor, is that like 20 feet over, or is that like half a mile down the road? How far away, just in general, are we talking?
Maybe 100 yards.
Okay. And then when you made contact with James McNamara that evening, where did that take place?
In the driveway of 4050 East Portage Point Drive in Onekama.
Is that the address where the incident was alleged to have taken place?
Correct.
Okay. Act about a firearm. You said you didn't find a firearm.
Correct.
Did you perform a search of that residence for any firearms?
Correct. Me and the deputies and tribal officers were given permission from Lauren to search the residence. We searched the residence top to bottom. We never located a firearm. We also searched the woods surrounding the property, did not locate a firearm. Searched the ditches along the roadways. I interviewed multiple businesses and attempted to get camera footage of the area. Most businesses didn't, either the cameras were not working or the footage was not good enough to make up even a vehicle on the roadway. So we were not able to locate a firearm or see if there was a firearm. We were not able to see where it went after the fact.
And James told you that he didn't own a firearm?
Correct.
When you made secondary contact with Lauren McNamara a few days later, you said she recanted. Is that your word or her word?
Her word was, I would like to recant my statements.
And when she said that, did you follow up with her to try and understand what she meant by recant?
I during our short conversation, I tried to, but she wasn't very willing to talk to me. So I wasn't able to get a whole lot out of her.
What did you take her statements to you to mean? Did you take them to mean that she had lied to you initially?
No, I did not.
I'd object to the extent that it calls for speculation. I don't know how he specifically knows what her thought process was. I mean, like that's kind of the matter at issue, I suppose.
Let me rephrase, Your Honor.
Okay.
Did she make any statements to you about not wanting prosecution?
Not directly saying that she does not want prosecution. That's that she would want to recant her statements.
Did she say that any particular thing that she reported initially was false?
She did not.
So she didn't discuss discuss with you at that second interview the particular facts of the case in any way?
No, it's just that she wanted to recant her statements.
Okay. And she didn't go into any detail about what she meant by that.
Nope, just that she was not in the right state of mind that night.
Okay. Did she give you any indication when she said not in her right state of mind? Was that her words?
Yes.
Did she give you any indication as to why she felt like she was not in the right state of mind?
No. She basically said that she wanted to recant her statements because she was in the right state of mind. Made a comment about me not being able to record her via my body camera, and then wished to go back inside. It was a very short exchange.
Were you wearing a body camera during the second interaction?
Correct. I am author. I have to carry a body camera every time. I have to have a body camera running anytime I make contact with any sort of civilian.
So were her statements to you recorded on that body camera?
They were.
Okay. You said you went there to serve her a subpoena, correct?
Correct. And that was to testify against James McNamara.
So that would have been for a preliminary exam?
Correct.
Did she accept service of the subpoena?
She did. She signed it.
You said you attempted to pull video footage from neighboring areas and none of it was useful or relevant?
Yeah, either the camera footage was extremely grainy to where you couldn't even make out a shape of a vehicle, or the cameras weren't pointing in the right direction, or there just wasn't any camera footage at all. The only footage I was able to get was from a local gas station, approximately a half mile from their residence, where you had seen Mr. McNamara drive his vehicle up, pump some gas, go inside, and then leave and head back towards their residence.
Would that have been before or after the alleged incident occurred, or are you sure?
I believe it would have been after the alleged assault, but I can't verify that off the top of my head right now.
I have no further questions, Your Honor.
Mr. Seeger, any follow-up?
Just very briefly, Trooper Hoffmeister. So one, Miss McNamara didn't want to be recorded. Is that correct?
Correct. She didn't believe that I had the right to record her. Then I was able to explain her that I had to record her per my policies.
Okay, but she did not want to be recorded. Is that correct?
Correct.
And making a false statement during the course of a felony investigation is also a felony, correct?
Correct.
All right. And you thought that you did a thorough investigation relative to attempting to locate a firearm, correct?
Correct.
All right. I mean, I think your testimony was that you searched the house from top to bottom. Is that correct?
Correct.
You looked in some ditches along the roadways. Is that correct?
Correct.
You attempted to obtain video footage from various cameras from local businesses, correct?
Correct.
And despite your reasonable efforts and investigation, you're unable to locate or verify that there was a firearm of any kind. Is that correct?
Correct.
All right. She also accepted service. Is that correct?
Correct.
But she recanted her version of facts to you, correct?
Correct.
Right. And so she would have appeared at the preliminary examination there then, correct, if she accepted service?
I believe the preliminary examination was canceled by the prosecutor.
All right. And so it's the prosecuting attorney that elected to do that, correct?
Correct.
All right. And so when in the order it says there being no corroborating evidence, that's the characterization of the prosecuting attorney?
I would believe so.
Okay. Yeah, I don't have any further questions, Sharon.
All right, Mr. Ziegler, any recross?
No, Your Honor.
Okay. All right, thank you. I don't have any additional questions of the trooper. So Trooper Hoffmeister, you're free to remain on the line or you're free to disconnect. I'll leave that up to you, okay?
All right. Thank you, Your Honor.
Thank you. Mr. Seeger, any argument that you'd like to provide in light of the testimony here today?
Your Honor, I would just ask the court to grant my original motion. And strangely, Your Honor, I'm still stuck on this whole, going to credibility. And I'm also stuck on the idea that this is a similar common scheme or plan in as much as like it all revolves around a firearm. And much like in our case, if it, depending on what the proofs are at trial, it's alleged that he sexually assaulted her with a firearm, and they were unable to retrieve a firearm. In the case that we just had testimony about in Manistee, it's alleged that she was assaulted with a firearm, and likewise, they were unable to find a firearm. Now, there may be differing reasons why allegedly one party was unable to find something in one instance and not in another, or whatever the case may be. But I think that those are questions of fact that the jury has to stop and consider. And I think that those are very meaningful things for Mr. McNamara to elicit during the course of his trial. And in order for him to have a meaningful defense, which he's entitled to do, I think that the subsequent act is part and parcel um, of his case. So I guess to that end, Your Honor, I would ask that the court allow the evidence to be admitted pursuant to 404B, 607, 608, and any other court rule that the court determines would be just and reasonable. I think that the rules of evidence are more inclusive than exclusive, Your Honor, in as much as, that this is a truth-finding mission, more or less. And I can't express enough that Mr. McNamara is the one who is charged with a very serious crime, Your Honor, because, and I told him that to the extent that you have a trial and you're unsuccessful, well, it's probably not going to end very well. But be that as it may, Your Honor, this case is testimonial in nature. There are not a lot of what I would consider to be direct proofs. I think that he has a very decent likelihood of success on the merits at trial, albeit I'm not on the jury. But ultimately, Your Honor, it's for the jury to make the decision. It's not for me. It's not for Mr. Ziegler. To a much lesser extent, I guess to a certain degree, it's for the court to make legal rulings. But the finder of fact is the jury, and the jury should be empowered with any and all information that may be relevant to their decision, which I believe that the case in Manistee is very relevant. Additionally, Your Honor, part of the reason why, and I understand that the court had quashed my motion or my subpoena of the prosecuting attorney, I think that there are parts that Officer or Trooper Hoffmeister would not be able to explain to the extent that Prosecutor Miller was not available as a witness, because he's right. To a certain degree, I think that statements could be elicited to a certain extent, maybe a lesser extent, through Trooper Hoffmeister, but there are other parts that I would not be able to make a reasonable connection to. For instance, Trooper Hoffmeister is familiar that the matter was dismissed, but that dismissal was based on a decision borne by the prosecuting attorney. And again, like his language that's in the order, and I'm just looking at the four corners of the document, due to non-cooperation. What might be non-cooperation to Trooper Hoffmeister may not be non-cooperation to the prosecuting attorney for Manistee County. What I do know is that he, in fact, is the one that dismissed the file. So again, I just want him to explain his order. Why he wrote it the way that he did, which I think the jury is entitled to understand that.
Okay, thank you. Mr. Ziegler?
Your Honor, Mr. Seeger's making the point essentially that he thinks it's relevant to the defense. He thinks that credibility is a key issue. Obviously, those things are true in a general sense, but then he just says that it should come in under one of these court rules. And I have to object to that because it really matters what court rule we're admitting it under. So first, he looks to 404B. 404B is for evidence of character that's not being offered for character purpose. It's being offered for some other relevant purpose. Mr. Seeger cites the common scheme or plan, and he says there's a common scheme or plan to lie to the police about guns being involved in certain crimes. I would not call that a common scheme or plan. I would call that a fact or circumstance that is common to both of these cases, but they're completely separate, unrelated police reports. There's no grand conspiracy where she's trying to defraud either Clifford McNamara or James McNamara or both by lying to police in both of these cases to further some grander purpose. It's not part of a conspiracy or a plot or a scheme or some connected goal that she's trying to achieve. Even assuming that the court accepts the testimony of Trooper Hoffmeister that she lied or recanted, or however the court wants to characterize it, that doesn't mean it's part of a common scheme or plan. So I don't think properly it comes in under 404B. The defense is offering it almost explicitly for a character purpose. It goes to her credibility. It goes to whether or not her account can be trusted. It's about her honesty. So it's not offered for some other non-character purpose under 404B. It's offered explicitly for a character purpose. And that's governed by 608. The defense doesn't want it to come in under 608, though, because 608 is quite clear that you're not allowed to use extrinsic evidence in order to go into specific instances of conduct for purposes of attacking a witness's character. And that's exactly what the defense wants to do in this case. So if it comes in under 404B, I think Mr. Seeger could put forward whatever evidence he wants about it. It's fair game if it's not offered for character. But since it is offered for character, the rule is quite clear. He can cross-examine the witness about it, but he can't prove the witness's answers are true or false by extrinsic evidence. He just has to take the witness's answers as he gets them, unless it contradicts a prior statement that she made under 613, at which point he can go into extrinsic evidence. And so the question is going to be not just, can it come in? It may well come in at some point under some court rule, but the question is, can Mr. Seeger just launch into it? Can he call in the trooper? Can he make it part of his case in chief? I don't think he gets to do that. I only think he gets to do that if, number one, the court finds it meets the threshold of 403 and it's worth opening the door in the first place. And number two, when he asks the victim about it, she makes a false statement about it, and only then under 613 can he bring in extrinsic evidence of prior inconsistent statements. So for those reasons, Your Honor, I would ask that if the court is going to find that it is not more prejudicial than probative under 403, that it hold that it's properly character evidence and it needs to comply with 608 and 613 before it comes in. I would also note, just to touch on what Mr. Seeger touched on at the end of his argument in terms of the prosecutor, I still don't see that the testimony of Mr. Miller would be relevant. Mr. Seeger wants to get into the underpinnings of the Nolly itself, but the reason why the case was dismissed is not relevant. It doesn't matter why the prosecutor chose to proceed or not to proceed. The only issue is the character issue of whether her statements are credible, and all of that can be addressed by the trooper. Whether the prosecutor found her credible or not, whether the prosecutor felt he could prove his case beyond the reasonable doubt, whether the prosecutor felt she was sufficiently cooperative, those are not relevant questions for the jury. And for all the reasons the court found when it quashed Mr. Miller's subpoena, it would not be appropriate to call him as a witness at trial. So that would be my argument, Your Honor.
Okay. All right. Thank you. Again, I had a chance.
Oh,
Yeah,
sorry.
go ahead.
Your Honor, I would just know the other thing that I would know, and I know that you had read our briefs, but the other common scheme or plan theory that Mr. McNamara was advancing was related to, like, perhaps the indiscretion that's alleged to have occurred in this case, because either it's a question of consent because the court had read that they previously were in a relationship, and then in the next volley he's sexually assaulting her with a firearm. But in the instant case in Manistee, there's an argument between the husband and wife relative to another male that's on her Facebook account. And so one of the other theories would be, Your Honor, is that it's a common scheme or plan for her to distance herself in any way possible, wherein, there's some allegation or argument that she's involved with some other man. So be that as it may, Your Honor, I guess I still feel strongly that it should come in under 404B, but that the other rules of evidence also permit its admittance as well.
Okay. All right. Thank you. I've heard the arguments of counsel today. They're consistent with what they've argued in their written briefs, have taken into account the testimony of Trooper Hoffmeister here as well. And looking at the law, first of all, I agree with Mr. Ziegler. It is very important as to whether and which rule of evidence this would be admissible if it is under. So I think it is important to address specifically the rules that would apply. Number one, the defense, for the reasons stated here on the record and in the written brief, are asking the court to admit this under 404B. And as both counsel are aware, 404B limits the introduction of character evidence to specific purposes. The party offering the evidence has to articulate a proper purpose for the admission of that evidence, and then show how the evidence would be logically connected to that proper purpose. The proper purpose has to involve something other than propensity. In other words, that the witness is just likely to do the thing that they're arguing that she's done in this case. And in my view, while they've articulated a proper purpose, which is a common scheme or plan, I don't think the evidence here is logically connected to that for the reasons stated by Mr. Ziegler. I think that that rule of evidence contemplates that a common scheme or plan is something that the individual routinely engages in for the purpose of typically, in the case of a defendant, of victimizing an individual or individuals. And so allowing that evidence shows how all of those different events connect together. I think really what we have here is exactly what Mr. Ziegler indicated, which is, a common element in terms of her claims that a gun was involved. But other than that, no real connection for the purposes of some overarching scheme or plan that she's engaged in here. And I get Mr. Seeger's argument that, if she thinks she's getting in hot water, then she defaults to this kind of MO or modus operandi of making up stories to get herself out of trouble. Even looking at it under that kind of a analysis, I don't think fits into enough of a connection under 404B. And I think what they really want to use it for, and I understand that, is to show that she is lying in this instance because she's lied in other instances. And that may be admissible for other reasons, as we're going to discuss in a second, but that's really propensity evidence. It's really her propensity to make up stories, and that's not clearly admissible under 404B. So the court finds that it is not admissible under 404B. Looking at it now as impeachment or credibility evidence, given the lack of any real physical evidence that this crime occurred, I think credibility is going to be a major issue at trial here, because the jury is going to have to hear certainly one story, and then Mr. McNamara chooses to testify another story, and the jury is going to have to decide which one they believe. And so their assessment of every witness's credibility in this trial, I think, is going to really be all that the jury is going to be able to rely on in making its decision. So with that in mind, I think the defense's ability to go into impeachment and the credibility of the complaining witness is something that is a big part of their defense, and the court needs to allow to the extent that it is allowable. I don't think it's going to require some type of mini trial of this incident that occurred in Manistee, because I don't think really the underlying facts of what did or didn't or may not have occurred specifically in that case are what's important. What's important is that she made claims about what happened, and then she recanted those claims. So in my view, it's not necessary for either side to either prove or disprove any of those things actually happened. Only that she made claims that those things happened, and then she recanted those claims. And I think certainly there's been evidence in the record here today that those two things occurred, that she made claims about what happened, and then she later recanted those claims. So how does that fit into this case? I think under MRE 608B, Mr. Ziegler is correct that generally extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support their character for truthfulness. However, the court on cross-examination can allow them to be inquired into if they're probative of the character for truthfulness or untruthfulness of that witness. So if the complaining witness does testify in this case, under 608B, the court can allow on cross Mr. Seeger to ask her questions about this incident in Manistee, and I find that he should be able to do that under 608B1 because I think they do go to that witness's character and are probative of her character for truthfulness or untruthfulness. So the court finds specifically that the defense can question her on cross-exam as she testifies about this incident in Manistee County under 608B. I think depending on her answers on cross-examination, then again, if she denies that she made those claims and then later recanted those, then I think now she's made some statements which the defense can show are inconsistent with prior statements that she made, both in claiming that those things happened and in recanting those claims. So to the extent that on cross-exam she denies that she ever made those statements or ever recanted those statements, then I think the defense would be able under 613B to call Trooper Hoffmeister to testify and give extrinsic evidence of those prior statements. So again, I think whether or not Trooper Hoffmeister can actually testify in this case about what happened and basically this testimony that he gave here today is going to depend on what she does or doesn't do under 608 on cross-exam. So if she on cross-exam says, yes, I made those claims and yes, I later recanted them, then I don't think there's a reason to call Trooper Hoffmeister or a justification to do it because she's not denying it. She's not making any statements that are inconsistent with her prior statements. And that'll be in front of the jury then. The defense will have successfully engaged in some impeachment there and called her credibility into question, which is what the rule allows. If she does deny it, then again, I think then the trooper may be able to be called under 613. So again, the court, specifically for the purposes of preparing an order, Mr. Seeger, the court's denying the motion, finding that it's not admissible under 404B, that the defense may inquire into that incident on cross-examination if the complaining witness testifies under 608B, and that depending on her answers, extrinsic evidence through Trooper Hoffmeister may be allowed under 613B.
Thank you, Your Honor.
Okay. Mr. Seeger, anything further we need to address for the purposes of this hearing today?
No, sir.
Mr. Ziegler?
No, Your Honor.
Okay. All right, thank you. That's all for today. Mr. Seeger, if you can just submit that order with the stipulation as to form or under the 7-day rule, and all parties are free to disconnect at this time.
Thank you, Your Honor.